The U.S. Supreme Court heard a controversial case today that could potentially overturn Roe v. Wade. That's the landmark 1973 decision that gave women the right to have an abortion up to around 24 weeks of pregnancy, which is considered when a fetus is viable. Here's a little bit of audio from today's oral arguments.
Your first question, and the only one on which we granted review, was whether all pre-viability prohibitions on elective abortions are unconstitutional. And then I think it's fair to say that when you got to the brief on the merits, you kind of shifted gears and talked a lot more about whether or not Roe and Casey should be overruled.
The harder questions are, should the court overrule and take that momentous step? And that's why we devote a lot of space to that very important issue.
And joining us are Ann Scheidler, president of Pro-Life Action League and coordinator of the overturnroe.org coalition. Jeff Stone, a professor at the University of Chicago School of Law. He clerked for Justice William Brennan when Roe was decided in 1973, and he's also the author of Sex and the Constitution. Peter Breen, vice president and senior counsel with the Thomas More Society, and Carolyn Shapiro, a professor at Chicago-Kent College of Law and the co-director of the school's Institute on the Supreme Court, and she's also a former clerk for Justice Stephen Breyer. Welcome all of you back to Chicago tonight. Carolyn Shapiro, let me start with you. Tell us what this case is about in a nutshell.
Well, the case is ostensibly about whether or not Mississippi's ban on abortion after 15 weeks is constitutional. But as you heard in the clip, what Mississippi has actually asked the court to do is to go even further than simply upholding that law, which I think undoubtedly they are going to do, and to overrule Roe entirely, and to completely eliminate the constitutional protection for women's reproductive rights.
And Jeff Stone, we mentioned that you were a clerk to Justice William Brennan when Roe was decided. Talk about why the court decided that case in 1973 the way it did, especially given the fact that 5 of the 6 Republican-appointed justices voted with the majority.
Well, to make a very long story short, one thing the justices came to understand, which was not popularly understood until that time, is that abortion had been fully legal from the ancient world of Greeks and Rome all the way up to the time the Constitution was adopted. And it was legal in every state in the United States at that time. And it was assumed to be just an ordinary right that women had. That was one thing the justices came to understand. The second was that because abortion had been illegal since the late 19th century, largely for religious reasons, very few people could speak about their experiences with abortion. Very few women could, because it was a crime. In the late 1960s, with the women's movement, women began speaking out and began talking about what their experience with abortion, illegal abortion, actually was. And it was truly horrendous. It was back alley abortions. It was self-abortion. Many women died from these experiences. And as the justices learned about this and read about it, they came to understand that this was a fundamental injustice in our society, equivalent in some ways to separate but equal. Certainly. It was a complete discrimination against women and their freedom. And the cliche was that men could get pregnant, abortion would be legal. And the justices were deeply motivated by this.
Certainly an evolving understanding from the justices back in 1973. Peter Breen, this Mississippi law is banning abortions at 15 weeks, although Carolyn Shapiro mentions the state wants to go further than that and overturn Roe versus Wade. But why 15 weeks? Why is that the limit in the Mississippi law? And I think you're on mute, Peter. Still having trouble hearing you. Okay, Peter, we're having some trouble hearing you there, so we'll come back to you. Ann Scheidler, I'll pose that question to you. Why 15 weeks?
The 15 weeks is plenty of time for a woman to have found out she was pregnant. I mean, I know that some states have trigger laws in place to ban abortion much earlier than that. And the argument against that from their point of view is that you might not even realize you're pregnant yet. 15 weeks gives you plenty of time to have found out that you are in fact carrying a baby. So that, I guess, is probably why they settled it at 15 weeks.
And as the U.S. Solicitor General argued today, said, quote, the real-world effects of overruling Roe and Casey, the other case in 1992, would be severe and swift. Carolyn Shapiro, what could the real-world effects be? Not just prohibiting abortion after 15 weeks. Could it be beyond that?
Yes, absolutely. There are many, many states that have trigger laws that will go into effect instantly if Roe is overruled, Roe and Casey, that could ban abortion entirely. We will see an enormous shift in the availability of this kind of health care for women around the country. Some states, like Illinois, have laws that will continue to protect access to abortion, but many, many states do not, and in fact have laws that will immediately go into effect. So there will be a dramatic change in the experience of people who are seeking that kind of health care.
And Illinois is one of the states that has a trigger law the other way that should SCOTUS overturn Roe v. Wade, that abortion would still be legal here in Illinois. Jeff Stone, Roe is 50-year precedent. Justice Kavanaugh made the point that SCOTUS has overturned precedent in its history. So how legitimate a precedent is overturning precedent in the Supreme Court?
I think the court does overturn precedent in fundamental issues, but almost always, interestingly, and the list of examples that Kavanaugh gave was really fascinating in this way, almost always to expand constitutional rights, almost always to recognize that prior decisions that denied, for example, criminal defendants a right to counsel, or that allowed the police to interrogate individuals who were accused of crime without giving them warnings of their rights, or they were allowed to introduce evidence seized in unconstitutional searches and seizures against criminal defendants. These were all decisions Kavanaugh rattled off, but they were all illustrative of the fact that when the court overrules major decisions, it almost always does it in a way that expands the constitutional rights of our citizens.
And that's an argument that
this will do that as well.
I'm sorry, go ahead.
Overturning Roe will expand the rights of the unborn child, whose rights have been ignored for the past 49 years. You have an injustice that's been in place far, far too long, and we need to be able to protect these children who are at the mercy of lots and lots of pressures that push women into choosing abortion when there are plenty of viable options available. And the pro-life movement is primed to be able to give women the support and the help that they need to be able to choose life, so mother and baby both get a chance to live.
Peter Breen, Carolyn Shapiro. I'm sorry. I want to get Peter Breen back in here. Carolyn Shapiro is mentioning that she believes the court will go all the way to overturn Roe v. Wade. Is there a decision here that's more narrow that would just decide on that 15-week law in Mississippi?
Right. Chief Justice Roberts had tried to get at that during the argument. The problem is, it appears by the end of the argument, both the folks on the abortion side and the folks on the pro-life side really agreed. Either the court's got to strike the 15-week law or strike the Roe and Casey framework. So there was something of an agreement there. And when you looked at the way the justices were doing their questioning, it does appear that they were leaning, the majority is leaning more toward striking Roe and Casey. And I would say one of the points that the Mississippi Solicitor General made was that we have had the experience of millions of abortions, and there are certainly anecdotal evidence of folks who had been pro-choice. People like Ronald Reagan had been pro-choice, but then saw the outcome of it over these past years and then changed their position. So that was offered by the Mississippi Solicitor General as well. The historical record, this was brought up during the argument, the historical record has really been corrected since 1973 through more deep research, where abortion was outlawed in most of the states in the Union at the time that we enacted the 14th Amendment. It was something that, even going back to English common law, abortion was not certainly not blessed. It was something frowned upon for hundreds and hundreds of years. So all of that together, I would say one thing. Even during the argument today, folks weren't really trying to defend the logic of Roe and Casey, but more to say, well, they've been in place, so leave them in place. Less that they were correctly decided in the first place, which is what most of us would look at as.
Carolyn, I'll give you a quick response here.
I would profoundly disagree with that description of the argument, but I also want to pick up on what Ann Scheidler said. which is when she, in response to the idea that this would be restricting, overruling Roe would restrict constitutional rights, she said, no, it would expand the constitutional rights of the unborn. What that means is the agenda here in the long run is actually not to leave it up to the states, which is what the rhetoric around reversing Roe versus Wade is generally, but in fact, to go even further and to declare that a fetus or an embryo is a human being, that is a person under the Due Process Clause and the Equal Protection Clause, which would have massive impact in all kinds
we only have about 30 seconds left, and I'd like to pose that question to you. Since Illinois is a state that does permit abortion, so are you saying this decision could open up Illinois' law to be challenged?
Well, we will continue to work to change Illinois' law. It is what it is right now, so overturning Roe won't affect Illinois for now, but the pro-life movement is not walking away from this battle. I've been doing this for 49 years. I'm not quitting, and I'm already older. So we've got lots of younger people coming up, and we're gonna fight for the unborn child until that every child is protected.
All right,
protected in law and welcomed in our society.
All right, this is going to be a discussion to continue, possibly a decision in the summer. And our thanks to Ann Scheidler, Jeff Stone, Peter Breen, and Carolyn Shapiro.
Thank you.
Thank you.